And I was thinking, well, if it's HPD, then you have to keep the frame, basically, right? You can gut the insides, do whatever.
The exterior renovations are typically a lot more expensive.
Yeah, I know. You can't just take it down, yeah. Yeah, this is kind of a hoarder type situation, yeah. Yeah, it's a shame.
We're in Yellowtown, and like, I've been here, you know, and water, and we usually just go across, way out in Miami for a bit, you know, and they're trying to screw off
I got one up there.
that is delicious too, this is a restaurant right near us, and we take it there, and it's, you know, across the bay.
What the hell they do?
Not that you've ever seen it before, but there's the fish.
Got plenty.
Good, it's an odd number.
Hey, Bill. Hey, Dennis.
I think everything's working out good. The extra sheet is, Rich gave me his bill, so it's.
Oh,
So I
okay.
would like to check it out.
Yep.
Extension and.
How you doing, Dennis?
Okay. Doing all right, just trying to find people to work. It's my constant thing every day. I got this crazy former client who keeps emailing me, accusing my caregiver of having robbed her. And this is like, 3 months after we stopped services. And it never happened. She's kooky. And, the stuff she's saying is just bizarre.
Right, crazy.
And she just keeps emailing me. And she's gonna call the this and the that and this, and I'm gonna get a lawyer, and I'm gonna do this, and I'm gonna do that, I'm gonna call the police, I'm gonna do this, I'm gonna. Like, finally, I said, please do.
What do you want?
I said, if you will stop emailing me, please do. I'm tired of seeing your crazy emails. Oh my God. Yeah, she accused me personally of identity theft. Yeah.
What do you do?
I have a home care business.
Oh,
Yeah,
okay.
yeah. Yeah, so it's like I stole her credit card out of her wallet, and this is woo. I was like, man, I thought I was done with her when we stopped service because she was, getting a little kooky.
It's almost harassing.
It's getting to that point where, and then there's this, I don't know if you've heard of Nextdoor. It's a dumb little social media platform.
Yes.
She got on that and started.
Damning you?
Yeah. Like,
Now that's a problem.
not a review, accusing me of criminal activity. Yeah, so I complained next door,
Yeah.
and they took her down. Because I told them, I said, you guys are liable as much as she is for allowing this stuff to be published. So,
Is it an elderly person?
yeah, she's not crazy old. She's in her 70s. I'm ready. She's a former therapist, psychiatrist.
Yeah.
And she's way too many medications. Yeah.
It's sort of built in, you know, two one-year extensions, or it's sort of automatic, you just have to ask for them.
Yeah, as long as there's no change to anything.
Right, correct. So, okay, guys. Good evening. The regular meeting of the City Planning Board, Cape May City Planning Board is now in session. In compliance with the Open Public Meetings Act of 1975, adequate notice of the meeting has been provided. If any member of this board have reason to believe that the meeting is being held in violation of that act, they shall so state at this time. Hearing none, we'll begin with the Pledge of Allegiance. Pledge of Allegiance.
The United States of America, and to the republic for which it stands, one nation, under God, indivisible, liberty and justice for all.
Karen, roll call.
Yes, Mr. Becerre,
Here.
Mr. Jones, Mr. Riggs, Mr. Crowley,
Here.
Mr. Gorgone,
Here.
Mayor Mullick, Deputy Mayor McDade. Here. Mrs. Reed, Mr. Lundholm,
Here.
Mr. Badousis,
Here.
Mr. Crippen.
Here.
Thank you.
Okay, the application for tonight is an extension of a preliminary and final site plan approval for 409 Elmira LLC, 409 Elmira Street, Block 1060, Lot 33. Mr. Monzo? By the way, everybody put your phones on silent. I had to Tony?
Thank you, Mr. Chairman, members of the board. Anthony Monzo from Monzo, Catanese, Delalis, representing the applicant. Initially, the applicant was 409 Elmira LLC. The ownership changed hands late last year. The current owner is 1842 Investments Cape May LLC. The new owner, who we are now representing, wants to explore financing and the market for the residential units, so is requesting more time. The approving resolution was December of 2022. The application for the extension was submitted October 31, 2024, so we were within the 2-year period at the time we submitted the application. I think because of the transaction and various other considerations, there were delays in getting before the board.
Let me just clarify one thing
Yeah.
procedurally, I think. Isn't an approval good for 3 years? What was that? This approval's good for 3 years.
This was final, preliminary and final.
2022.
Final, I think, is 2.
Finals
Is
2
it?
years.
Oh, okay, I stand corrected, okay.
Well, because we had preliminary and final, I think once you get final, you start the clock on 2 years.
On the 2 years.
Okay.
But per the ordinance, the board has discretion in extending it for up to 3 1-year periods, so that we don't have to come back next year. I would ask for the 3 years, but if the board wants to shorten that, that's fine, and we'll see how things are at the end of 1 year or at the end of 2 years.
Mr. Monzo, are you aware of any changes in zoning or the zoning ordinance that would affect this site?
I am not aware of any changes that were made that affect this site. This was a permitted use. It's the C1 zone with residential over commercial that's permitted, over permitted use. There were some minor variances granted because of the back out, mainly the parking, which really was difficult, but I believe we had, I'm not sure if we had sufficient parking, but I know we had back out parking until Elmira, which required a variance.
I can summarize the variances. So there was a parking variance for the number. 8 were required, and they provided 5.
Excuse me, does that include the two spaces on the city property?
It did not.
So they had 7 spaces.
Well,
The ordinance requires on-site, so that's,
Fine, okay.
so
And I remember that, Craig, when,
Yeah.
even because they were not on-site, we couldn't count them.
Right.
And needed.
But it's
included in the
used towards your
variance.
justification for
Yep.
that variance.
And that was discussed.
Right.
at the last-
So, and then there was another variance for the extended curb cut along Elmira, and then finally for the parking setback and the side yard setback. Those were the three variances. All of the other bulk and area criteria were met.
Mr. Monzo, you mentioned that you might be looking to get the 3 years or 3 one-year extensions. Is there anything in particular about what you know about your current client that would lend you to want to request that?
They are, in fact, they're working on an application to come before this board either probably in May. And while they're undertaking their plans to develop the property as approved, they want to at least make some use out of the property as a private club with about 20 seats for private membership on a temporary basis. That is considered a change of use. So that may last 1 or 2 years while the plans to develop the property are being explored further. Ownership changed hands again at the end of the year, and the new owner is now looking into the market, looking into financing and seeing if there's a market for the residential use as approved. And we believe there is, but it's going to take a little bit of time.
So is it your understanding that they would come back to the board to get approval for this interim use that you're describing?
Yes.
Okay.
We're only extending the approval for what we passed.
Understood. I just want to have an understanding of where things might go.
Any other questions? Dennis, put your mic on.
Could you explain again, Craig, your comment on page 4 or 5?
Yes. So extension of time comments is listed at the top of that page. And it has the section that contains the provisions for the time limit for final approval and extensions. So once you get final approval, it says that final approval shall expire 2 years from the date of final approval unless the applicant has secured and maintains a building permit to commence construction. That has not been secured. The planning board may extend final approval and the protection offered under subsection F herein for 1 year. The developer may thereafter apply for an extension of final approval for such additional period of time as shall be determined by the planning board to be reasonable, taking into consideration the number of dwelling units and the non-residential floor area remaining to be developed, economic conditions, and the comprehensiveness of the development.
Where did the 3-year come in?
Okay, so this is our ordinance is a little bit different than the language provided in the municipal land use law. The municipal land use law provides that you're allowed up to 3 one-year extensions. Is that correct, Mr.
That's
Mon?
correct,
I
yes.
believe, so I'm just going off the top of my head, but, so I believe where it says, the last sentence, the developer thereafter may apply for an extension of final approval for such additional period of time as shall be determined by the planning board to be reasonable, shouldn't exceed what the municipal land use law provides for, which is the 3 one-year approvals. Now, some boards will grant them all at one night. Other boards will make them come back each year and provide testimony with regards to the status of the application, the economic conditions, et cetera. It's up to the board.
So under the land use law, when does the applicant have to apply for the first of these extensions?
So long as they got their application in before the extension ran out, I believe it's valid. Now, they're actually allowed to come back retroactively, like, I'm talking legal stuff, but I'll let Rich
We have a
handle.
lawsuit about this provision.
Okay.
There's actually a decision written on this very ordinance. So at one point, I knew this thing crazy good and crazy careful. Because
Yeah, why are you
the
asking me?
I bet. Well, no, this came up in the JED.
That's the wrong guy.
Yeah, it did.
In the JED, and
Yeah.
you denied the extension.
Right.
So there was a big appeal about that, and the reason you denied the extension was there was a change in the circumstances surrounding that area, because the parking got much more complicated, the beach had formed down there. So, we had a big lawsuit about whether or not.
I also believe they failed to file an application within that 2-year period.
That's where I was going.
I think
Well,
that's,
a
I
whole
think
nother-
that's,
That's a whole other complication. Now, you can, As long as you file between the end of the second year and the end of and beginning of the third year, it relates back to the beginning of, it's as if you did it on time. So you have to do it within 1 year of the 2 years. And then it goes back to and we only get an extension from when it expired. Okay, so it's a very complex thing, and I wrote pages on this in the appellate brief, because our ordinance doesn't track the MLUL as, we're accomplishing something different here. Ours makes the thing expire. The MLUL is designed so that when you get preliminary approval, it freezes the zoning at that time, so that they can't change the zoning during that period. And then there's a final approval, and then there's a period that once you have final approval, you have final approval. So if zoning changes, it doesn't matter because you have final. Well, what ours says is you have to start doing something within 2 years or it expires. Okay, so that people don't just get approvals and then sit on them for a long time. Part of that was in reaction to something that happened on Washington, I think. So ours is different. So when you try to put ours and make it lay over the MLUL, it doesn't fit perfectly. But the court validated our ordinance and said that we can do it the way we do it. And it also said that we can consider not just these 3 things, but we can also consider what has happened around the site to whether or not that approval still is viable. And we have to listen to their reasons. It's always my preference that the applicant testify as to the reasons, because we actually need personal knowledge. But nevertheless, Mr. Monzo has testified to the reasons why. So there's also a quirkiness, not to add layers to this, but that stuff about if you read the first sentence, right, the second sentence is the planning board may extend final approval and the protection offered under section F hearing for 1 year. And then the developer may thereafter apply for an extension, and then it gives the reasons. So argument can be made that for that 1 year, there really isn't a standard established for whether they can extend it. So I think you kind of get it. The 1 year is fairly easy. When they ask for more than that, then you got to start thinking about, well, do you really want to freeze that in place for more than a year? That's a complicated area. I remember there was the bus station was behind it. There was some parking of ours that they were using. It was very dynamic. It was a weird application. I mean, it just kind of was. There was like commercial stuff on the first floor and.
Yeah, if I can just, I mean, the bus area behind was an area that we thought initially was an access area. When we found out it was a private road owned by Department of Transportation or New Jersey Transit, we reconfigured the plan so that access came in off of Elmira. Those 2 parking spaces are permanent. They were granted by the city when they widened Elmira Street, and they took parking from the depot, and in exchange, as part of the deed of easement that was granted, the city awarded 2 permanent parking spaces, the first 2 on the parking lot adjacent to the property.
Were they the property's parking spaces, or were they just the city's parking?
No, the depot lost 2 parking spaces as a result of widening Elmira Street.
Yeah, no. What I'm saying is my recollection is that some of the parking that was being used by this project was actually not their property. Am I wrong about that?
That's correct.
That's the 2 parking?
All right, 2 of those
Even though
spots
the
were
city, even though the applicant had the right, because it wasn't on-site, Mr. Hurlis is correct that it needed to be included in the variance because it wasn't on-site, it was on an adjacent property, but it was justification for the variance.
But you're here tonight asking for
1 year
at least
extension.
1 year. You're hoping to get a
Since
full-
we're 3 months, I mean, my only suggestion, first of all, the ordinance says for 1 year, then it says the second sentence, up to 3 such extensions may be granted. It doesn't say it has to be all separate times. But since we're into the first year by about 3 months, I would suggest maybe for 2 years, because it may be hard to get everything done and get permits pulled by the end of the year. because it relates back to when the approval was given. So that's why I think 2 years might be more
But
appropriate.
Mr. Monzo, you're saying that there might be a change in use. And so from my position, I'd like to understand what that change of use is before I would grant for 2 years. So I think at a minimum, I would expect the applicant, the new owners, to come back and have some discussion in front of this board as to what they intend to utilize this property for, even if it's an interim.
Yes, well, we are working on an application to come back in May on that change of use.
Okay.
There's an application that was submitted to HPC.
Okay.
That elaborates on that as well. But the changes is mainly,
About the future?
no, just temporary, because they don't want to operate a restaurant, but they want to get some use out of the property during this interim period, so they want to make it just a private club
Okay.
that has 20 seats in for private membership. It's considered a change of use, which requires, even though there's no changes at all to the site, it's going to remain exactly the way it is, other than renovating interior and facade changes to the building, which is why we need to go to HPC. Because it's a change of use, it requires board approval.
But, so I'm clear, you're asking for a 2-year extension on, for that utilization of the space of the
No,
building?
no,
The approved,
for the prior approvals.
For the prior approvals? Okay,
Prior
all right.
approvals, yes.
They can't do anything new without coming to us. This is just to extend it while they try to figure out what they're doing, and they're having some economic issues about determining the viability of the residential units, and there's been a change in ownership, and it's delayed, and that's the gist.
My question is just what I've heard in the past, is that private clubs aren't allowed in Cape May.
sure they are. Marlin Tuna
So
Club.
I think it's a permitted use in that zone.
What's the tuna club?
Marlin, the beach club,
Beach Club,
Yacht club.
Yacht Club.
my backyard.
You have to-
The Crowley Club.
But I don't want to get too caught up on the proposed use, it's kind of like floating out there. But your primary reason, I thought you gave in the beginning, is that it's been a change in ownership, and they're examining the financial viability of the residential units.
Yes.
And they may make some interim use of it, so that's why you would, for 2 years, because you're gonna go back 3 months anyway, so it's really only a year and 9 months, and you want those 2 years to figure out what they're gonna be able to do with the property.
That's correct.
Any other questions?
Yeah, I have another question about this, and I'm sorry for being dense, but this application, this approval expired in 2024,
Correct.
and there was no building permit issued prior to that.
Correct.
And now we're being asked to extend this approval.
That's correct.
Yes, and you have to do it. There's a case, there's a case on this, okay? And you're allowed to have these kind of expire, it's written by Judge Serpentelli, the case. And it talks about, you can have these shorter periods to expire, but they can't be less than the 3 years that's in the MLUL. So, and he talks about the same idea of applying within those 3 years, you have to get your application in within those 3 years. And when I dealt with this in the appellate division, I said if we did this sometime between the second and third year, it might be a problem. But in the jetty, we were in the 4th year or something, 5th year, something crazy like that. So I'm telling you, as a matter of law, they applied on time. That is not.
Well, we actually applied before the expiration.
Applied in October.
And under the MLUL, as long as you apply before the 2 years is up, you're,
I'm just telling you,
yeah.
do not deny this based on the time that they applied. They are within time to apply. So if you have another reason you want to deny it, then you can articulate that, but that is an invalid reason to deny it, in my opinion.
Okay.
All right, any other questions? Anybody care to?
No, I missed their original hearing, so can I vote?
Yes.
Anybody care to make a motion to extend for 2 years?
I'll make the motion.
2 years from,
A second.
I'll make the motion to extend for 2 years as of December 2024.
I'll second.
Deputy Mayor McDade motions, Mr. Lundholm seconds. Mr. Gorgon?
yes.
Deputy Mayor McDade?
Yes.
Mr. Crowley?
No, I vote no on this, and I voted no for the first time it was around because the way the property is configured, particularly with the backing out of the parking spaces into Elmira Street cause,
Dennis, you can't vote on an application, so it's because you voted against it. You can't vote on the merits of the application for an extension. You have to vote whether you want to extend
Like,
it. or not.
that's a invalid basis to deny the extension.
okay, then I vote,
If you want to articulate something that has changed from when you voted, from the first application till now, something has changed, either a significant site condition or a zoning change, then you can articulate that. But to say that I'm voting no for the same reason I voted no when it was first here, that's not what you're voting on now. You're
okay,
voting on
then
the
I abstain.
You can't abstain unless you have a reason to abstain.
Then I vote yes.
That's intellectually honest.
Mr. Lundholm,
Yes.
You've taken my other two choices away from me, so.
Mr. Paducis,
Yes.
Mr. Crippen,
Yes.
Mr. Bezare.
Yes,
Thank you.
okay.
Thank you.
See if that-
Oh, we didn't open to the public, so.
Oh, we did not.
Okay.
We're holding our decision in abeyance until.
I make a motion, we rescind our previous vote until we hear from the public.
Sorry for my jogging attire, I forgot that this was this evening, but I live across the street.
Hold on,
Can you move up to the podium? Thank you.
I live across.
oh, hold on, ma'am.
Is the microphone on?
Is it on?
Yep, it's on.
Okay,
Well, I have to do this in a certain way, okay?
yeah,
Can you please state your name and spell it?
yes. My name is Lindsay Michael, Lindsay Michel.
Okay, and where do you live? Lindsay?
I live at 523 Lafayette Street, which is across the street from 409 Elmira. We're on the corner.
Okay, do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I don't think it's testimony, but yes.
It is if you say it. Go ahead.
Okay. I have a question because there was some construction going on at 409 that was shut down, and there was a notice posted that it was like being conducted without approval, I guess. So my question is, did that have something to do with the proposed like change of use to make this into a private club, or was that something to do with the previous
I can address that.
usage?
There was some interior work being done with the understanding that under construction, it was in the same use group as the restaurant use. Private clubs and restaurants are in the same use group for construction purposes. So they stopped work until that was rectified. Since then, the zoning officer signed off, the construction official signed off, and they allowed them to continue interior work only. So they're just doing some interior work, maybe, nothing significant, and they're going to go and not start the exterior work, which is basically windows, doors, and some facade work, until there's HPC approval and also planning board approval for change of use. So right now, only interior work is being done and permits are issued.
Okay. It just had looked to me like the interior work had shut down as well. But yeah, so that was my first question. And then secondly, the parking spaces, are you going to be like cutting into the sidewalk in order to add or provide the 8 parking spaces that you're talking about?
There will be a hearing on change of use that'll address future site considerations. That's not what this board's considering tonight. But to answer your question, no changes will be made on the exterior site other than the building itself.
Okay. And so the interior construction will resume before that May hearing?
The interior work only is being done, yes.
Okay. I think that's it.
All right.
Thank you.
Sure.
Thank you.
Thanks.
Tony, just so that my silence doesn't imply that I agree with that decision, I don't understand how they're doing interior change of use without a variance.
There's a use group, I don't even know the technicality, RA2U, whatever the use group is, clubs and restaurants fall into the same use group for construction purposes. So based on that, between the construction official and the zoning officer, they agreed that interior work only can be done, with the understanding that just because interior work is being done, it doesn't mean it's a change of use for zoning, that would have to come before the board, and they're doing that work with the understanding that it's at their own peril, if the board approves or disapproves the change of use application from a zoning standpoint.
And so you're saying that because the current dormant use was a restaurant? Is that what you're saying?
Yes.
Mr. King, may I ask, I'm sorry.
I'm sorry, go ahead, Ms. Mc-
I just wanted to ask whether or not we could just follow up. Not that I don't trust Mr. Monzo, but I'd like to hear from the construction official as well as the zoning official. I'm not planning on holding this up, but I just would like a follow-up on that from this board.
Or at least a letter.
At least a letter in the file.
Okay.
Thank you.
Yeah, and there is a zoning permit issued, and also an application with full set of interior renovation plans.
Ricky?
So if it's going from a restaurant to a club with the same use, why do they have to come back?
I had that discussion with Bruce Britton. He said, under the zoning code, the permitted uses in the C1, correct?
Yes.
In the C1 zone, restaurants are in one category, private clubs are in another. So from a zoning standpoint,
Okay.
we have two separate permitted uses. From a construction code standpoint, private club and restaurants have the same use group, and therefore, they don't consider that to be any change of use from a construction code standpoint.
That's convoluted, isn't it? You really got to
little
jump.
goofy.
You got to jump through hoops on that. Jesus.
Anybody have an Excedrin?
I don't know enough about it to comment on it. Different uses can have different parking implications. There's site plan, change of use in a commercial zone.
The fact is, they're going to come
But
back.
that's not the issue that's here, so.
Yeah, we're not disputing that from a zoning standpoint, this is a change of use, and we're working on plans to submit probably in the next week.
The change of use triggers site plan approval, so they're going to be required to come before you. and-
Yeah, that's just, I guess that's what's confusing me, but that's fine. So,
I mean, they can, just so, I mean, they can do all these interior renovations and
them.
reopen it as a restaurant without
Right.
even coming
Right.
to the board.
That's why I'm
So what they're doing is consistent with restaurant use inside, so.
Okay, so, but to this young lady's point, your client acknowledges that they're not gonna open as a club without coming to this board.
That's correct,
So they're doing this work, but they can't start using it for something different until they come here,
yes.
okay?
Okay, that's okay.
No, it's actually a very good question.
All right, so the vote stands?
Yep.
Okay,
I agree, yeah.
all right.
Thank you again.
See ya.
Thank you.
All right, bye.
Thanks, Tony.
All right, so the next thing on the agenda is this lovely piece of work, the State Development and Redevelopment Cross Acceptance Response.
So I can talk to you guys about that.
That's what you're going to have to.
All right, so
Very exciting stuff.
you were invited, that you, being the city, were invited to participate in the cross-acceptance process for essentially the state plan. It's called the Preliminary State Development and Redevelopment Plan. It's effectively called the state plan. The last one that they adopted was in 2001, even though they're required to re-adopt the state plan every 3 years. They hold us to a 10-year timeframe with our master plans, but they have failed to meet their.
Shocking.
Yeah, so, but anyway, they're finally doing it, and what they do, the process is that the county acts as an agent for all the municipalities within the county, and they essentially take the city's comments and package them for the state, for the adoption of the state plan. They encourage public participation, as well as the governing body and the planning board. Generally, it's my experience that the planning board leads the charge with regards to review of these maps and plans and recommendations that are in the state plan. So I strongly recommend that the city does participate in this. So there are some dates. They have set up a new process. They altered the process a little bit every time they kind of do this. But they have this new process called a CART, which is the Cross-Acceptance Response Template. And they expect us to answer that and submit that to the county by May 30th, 2025. So that's the first deadline that the city would have to meet. And let me explain the importance of the state plan. So the city went through this process before, and we also went through a petition process where the city was deemed to be a town center. That changes your planning area designation. We're a PA2 when we received that designation. That expired in 2023. We revert back to the underlying planning area, which is a PA5, an environmentally sensitive planning area. That has implications when you're doing large-scale development that requires CAFRA approvals. It also has effects on the city's permitting process. So it's a good idea to follow up and probably have that center designation reapplied for and secured. So that's one of the things that can come from this process. Other towns have, it has implications, the state plan and the mapping have implications on sewer service areas. That's not really going to affect you, but a lot of other towns that I've represented in the past, it's very important for them to do that. But to me, that's your biggest impact, is having that designation put back in place. There are other implications and recommendations that could in fact impact future planning, so it's a good idea to participate in the process, evaluate the maps, evaluate the recommendations, and make comments back to the county and have them carry that to the state. My recommendation is to participate in this process. I don't know whether, I guess it's a pretty complex process. I tried to water it down and explain it, but it's essentially it's our master plan at a state level. And the biggest criteria are these planning areas and the mapping that results from them, and the impacts on the towns.
Where do we get information on that?
So all of this stuff, and if you click on the documents that were provided to you, it will take you right to the links. So I think the draft state plan is online. You can click on that. The cross-acceptance manual, which kind of takes you through the process, who represents you, what the process is, what are the deadlines, the CART, that is also referenced. So it's an important process.
Craig, from the city's, excuse me, from the city's perspective, are you taking the lead on this and sort of, as you do with the master plan,
Yeah.
taking us through it? You'll come back? I mean, what's our participation level? And then obviously,
Usually, so I kind of take direction from the city, but what I've seen in the past is the planning board just certainly is the tip of the spear for this. And then what their findings are forwarded to the governing body.
Okay.
The governing body would accept those, and then those, after that has happened, and any other, the state plan encourages all the other Historic Preservation Commission be involved, Environmental Commission, they can all comment. By the time it gets to the governing body, all of that comment should have occurred, whether it's before the planning board level or.
sure. I'm just thinking about, you're saying May 30th, 2025, we're at the beginning of March, with 8 weeks ahead of us, and all of that work to be done, both at this board and then through the other commissions, and then up to council for endorsement and approval.
I could comment, can I comment here? Because a couple of things have not happened in this process that happened 10, 15, 20 years ago. In 2009, Craig, you remember that the city was involved in the plan endorsement process, which was part of, at that point, some requirement that the city would do this and get special treatment in terms of applications and grants.
That's what I mentioned.
Yeah.
That was the center designation.
The center designation and the plan endorsement process was a pretty elaborate set of things that the city had to do in order to qualify for that. In this new state plan, and I would recommend that everybody read it because it's a significantly different document than the state plan that was issued in 2002. There's lots of things in here that are going to raise some question marks for a town like Cape May, because the way they're looking at it now, we're not a center anymore. We're an environmentally sensitive area. And if we, for example, ask for a center designation to be restored, we would be surrounded by environmentally sensitive areas, but we would be a town center. Different regulations, different requirements would apply for each of those groups. The amount of time that we're being given, not from you, Craig, but from the city, from the state rather, to digest this whole process is just unrealistic. If the city is going to the city at this point has pretty much only two options, I think. One of them is to just lay down and take what the state gives us because we don't have enough time or resources to actually plan through this thing properly. There's a lot of stuff in here that Cape May needs to read and read carefully because it's not for Cape May in a lot of ways because Cape May is a unique place.
So, sorry.
I got a real problem with this, and I have a real problem with it primarily because I have a lot of history with it. Because as Craig, you remember, in 2009, I was the chairman of the Plan Endorsement Committee, which was part of this process. And the
God bless you.
the backward direction,
I went through that in Dennis Township. It was not fun.
it wasn't fun.
It was not
wasn't
fun at all.
It was a lot of work, and,
Yeah.
and I think back on that process, the entire community was involved because we were mobilized to input what we think Cape May should be and how the state plan should meet our needs. This document that just came out in December of 2004, and we're being given 10 months to read, digest, and respond to it. But all the responses have to go through the county, and whatever we say may or may not be even considered by the county, let alone by the state. The amount of involvement by the city of Cape May is, in my mind, problematic because we're up against a timeline. And I don't know how to solve it except to maybe dig our heels into the ground a little bit and start putting together some recommendations to the council, that the council ought to be the ones log jamming this thing a little bit and slowing down. I don't know how that happens, but it
I don't
certainly.
know that they can. This is happening at every county level, and they all have the same time frame. The first deadline for May 30th is pretty much to answer these, 11 questions.
Right.
So it's not insurmountable. It's something that, as a planner, I can do that on behalf of the board. I don't know whether the board wants to set up or the board, when I say board, the governing body may want to set up a subcommittee. It might,
Well, I wanted to, there actually is a subcommittee that has been set up recently by the city manager. Mr. Bill, you're on it as the Land Use Development Group, which has representation from planning, HPC, zoning, shade tree, and environmental, correct?
That was the meeting we went to the other day.
Yeah. So there has been a group that's been formed,
There's nothing done.
but what,
No legwork, no discussion.
right, but that might be the forum
That might-
with Craig's
exactly.
participation in order to have this kind of discussion that needs to evolve over time. We get the first piece in that Craig perhaps put together, but then that body, that group exists currently. It just got put together and could be sort of the formation of working on this as an initiative. Has the representation.
And if you look at what could be required by a town in terms of data submission, it's a mountain. It's a mountain of data.
So you're looking at the petitioning process, and I would lead if my proposal would accept it, I would lead the charge on that. The state cross-acceptance is not that document intensive.
Well, it'll ultimately have to be if we're to make
It
a
will,
case.
yes, it will lead to that, but the initial review of the plan is more about just review and comment, and saying, this goal of the state plan is directly inconsistent with planning in Cape May. And those are the kind of things that you're coming out with.
Where is the plan?
The state plan's on the website.
It's on the website.
There's a draft state plan that's been provided on the
And
website.
it goes
It's 167 pages.
by
It's
municipality?
this thick.
So
It-
I
it-
mean,
Brandon-
If you go on the website, there's I think they call it a user-friendly version of this proposal.
Yeah.
And in that user-friendly version is a link to the state plan. I didn't print it off either, because it is 175 or so pages, but I did read all of it, and it's got some real monumental issues that Cape May either makes them address or has to live with for the next 10 years.
It's not town by town specific.
No, that's the other point, too.
It's more state-related, and where it gets town-related is these planning areas. So if you're a planning area two, and they're recommending this, this, or that, and then you're mapped as a planning area, or changed, your planning area changes, that has implications.
So we're no longer a town center.
You lost your town center designation in
We should-
2023.
We should make.
So
might
that,
want
so
to get
as
that back.
participating in this will start you down that road to getting that town center back.
But I think there are implications in doing that, and those are what we need to understand. The difference between staying in the current designation versus going back and converting back to a town center. What are the implications to that, rather than, and I think, have you had any conversations with Mr. Dietrich about this at this point?
No, he just forwarded this to me.
Okay, all right.
And said, please discuss this. with
Yeah,
the planning
okay.
board."
So, I mean, in my view, there sort of needs to be, I mean, you know, Paul's an engineer, and in Craig's role as the, you know, board engineer, there needs to be something that says, what do we need to get to first? There's a lot of work to be done with this, and a lot of discussion as to which designation we want to be and what has the impact for that. But I don't want to jump to the end or the middle of this process until we can get through what we need to get done by May 30th, if that's an impending deadline.
Well, before we go much further, everybody who's going to have a say in this issue at this board really ought to read that entire plan, because what you'll find is that the plan is state-centered, and that power and authority flows down from the state, and the state has set up at least 10 areas of required organizational and procedural policies that everybody has to comply with. And it isn't a two-way dialogue between the state and the municipality. It's a one-way dialogue, because nowhere in the plan does the state give a municipality the option of saying, I don't want to do that.
Okay, I mean, yeah, and that's not uncommon.
No. But what's uncommon about it is that the scope and impact of this particular state plan is way different from the one that we're living with under the 2000.
I understand. I think what I'm just trying to say is, what are the first steps that we need to get through by May 30th? And then there needs to be an understanding at council and the governing body as to what needs to be accomplished and the implications and the decisions as to which way we're going to go down this. You know, it's not like the changes that the state was proposing with the FEMA, guidelines and the sea level and, raising the roads and all of those other things. I mean, there are sometimes these decisions come down from a state level that don't take into account local impact. It's our role to make the decision that's best for the city and push back on those decisions. So
Well, between now and May 30th, you're going to have a hard time getting all the boards together
you don't need to, though, right?
in unison.
Do you not just need to get this questionnaire?
Craig, am I right or
My
wrong?
recommendation will be,
Yeah.
is to speak with the city engineer about which is the appropriate committee to handle this. I will submit a proposal to him to do this work, and hopefully it's approved, and I will work with whichever committee is deemed appropriate, and hopefully there's representatives from the planning board on that, and we will start working through this process.
Am I right or wrong about my assessment of this plan?
The state plan, and they mentioned home rule in here, but as I've found over the last 10 years with regards to the ordinances that we've been forced to adopt, that have been handed to us from the state and not allowing us to change those, the electric vehicle ordinance, the stormwater ordinances, they have been very heavy-handed at the top and allow us very little home rule per se. So I think you're touching on a couple of those issues.
And a good example of how that's happening even before this is that whole business we had with the elevation, the flood elevation issue,
That's the one she just mentioned.
which is just, we still don't know what we're going to have to live with.
Right, so,
And that's getting rolled into this as a don't talk, don't discuss issue.
right, so,
Well, so Craig's suggesting that I guess I talk to Paul and see if he can set up, or work with the committee now.
Right, there may be already an appropriate committee set up to address this, as the deputy mayor had indicated.
It'd be nice to have, I mean,
But,
Dennis understands this more than any of us.
yeah, I mean, so we may want to reassess or include other members, or, you know,
Right.
the state, the template mentions all of the boards and commissions, so I don't know whether it's fully represented. If it is, great. If not, you know, but we can make adjustments. And certainly, the board can make recommendations if they want to see, you know, have more of an involvement.
I, for one, don't completely understand the whole,
Okay. It's essentially a master plan on a time schedule
2 months.
done by, headed by the county for each town. And so, yeah, it's, the first step is May 30th. So that's,
And those are the 11 questions?
and then there's 9 weeks after that, I think, or I'm sorry, no, that's 9 weeks before. And then there's,
Are the 11 questions you're talking about?
It's, the deadline's October the 3rd of 2025 for this plan to be
Right.
done.
Please indicate, please elaborate, please let.
That means everybody at the county and every one of these municipalities has to get on board.
this, there was something that was in here, it's called a cross-acceptance response template,
A2.
and that is what's due on May.
Gotcha.
That's the one that's due in May. And that's not ridiculous, and we can certainly meet that deadline.
Well, not to come back, but we can meet that deadline, but if you dig down into what they're asking for, there's some landmines in that thing, and they're big. And we did get a copy of that, so we can all read that.
You have to go,
It looks like there's a public hearing where you can, they have some information on March 26, 2 to 4. I think it's, and I think it's a Zoom.
Yeah, it's at Cresthaven.
I personally think Craig, who has done the master plan here for 20 years, should prepare a draft of answers to those 11 questions, so that when it does get to a committee or something, you're kind of starting from something on paper, and you can agree with it or disagree with it or add to it. But if you just leave those 11 questions blank and start talking, you'll never get them done. Nobody knows more about, with all due respect to Paul, nobody knows more about our planning than our planner for the last 20 years. So he should
yeah.
prepare a draft and then work from there.
I would fully agree with you, Mr. King. My only point was to make sure that this was on Paul's radar, so that he's
Absolutely.
getting it in front of the governing body and any other committees that are required as part of this early process. And then to start to think about what is the strategy and what is the framework for getting the next
Yeah,
pieces of this.
I'm just saying, sometimes it helps to start with
Definitely
it.
on Paul's radar. The invitation went to him, and he forwarded it to me to discuss with you guys. So that's where we're at. And I think we just need to move quickly on this.
well,
can't
why don't
sit
we
around.
have a motion to hire Craig to fill this 11?
That's where I'm not sure whether
Okay.
the board has
Right.
funding for this or not.
So I can make a motion that I will have a discussion with the governing body on the fact that we've got this immediate need for the completion of this 11 questions associated with this document, and that we need to engage Mr. Hurlis for that, to prepare that, so that we meet the associated timeline as set forth.
Second the motion.
Good motion.
Makes sense.
Deputy Mayor McDade motions. Chairperson Bezare seconds. Mr. Gorgon?
Yes.
Deputy Mayor McDade?
Yes.
Mr. Crowley?
Yes?
Mr. Lundholm?
Yes.
Mr. Paducis?
Yes.
Mr. Crippen?
Yes.
Mr. Bezare?
Yes.
Thank you. I think that's everyone.
And can I just make one comment about just a comment, if you haven't done it already, it would be very helpful to read that template on cross-acceptance responses, because, as I said before, the landmines in this whole process are buried in those questions.
If anybody wants me to print the state preliminary draft,
Just provide the website so that we can go online.
Well, you already got it, because Karen sent it to us.
Yeah, if you, so in your documents that you received in the email,
Okay.
There's links.
there's links. If you click on, and
Okay.
if you click on them, they will direct you right to that website.
Okay,
So it is searchable.
okay.
And I will send Karen the decision in the Jetty case that goes into some detail about that ordinance. If anyone is curious, you don't have to read it, but if you're curious about it, there's a lot of detail in there about how that thing works and how it differs in the MLU and how they interact, and I'll send that to Karen. And if you're bored to death, you want to read that after you get done the 186-page state plan, you can read that.
That's why we pay you to
Just
read it
before,
for us.
before we vote and move to the next subject on the payment of bills and stuff, just something that's related. So in addition to the state development and cross-acceptance process that we're going to be dealing with, there have been some things that have been popping up with the zoning board and applications and that kind of dovetail into our implementation of the master plan recommendations. Some of the things we've talked about, but they're starting to pop up more frequently. We've had some habitable space, garage conversion issues before the zoning board. So that seems to be, coming to the forefront. I know there's been a recommendation for reviewing the signage provisions within the ordinance. And there's also, I noticed a couple of times in the last couple of months, we've had some applications where applicants have been required to come back to the board for relatively simple things, and they really weren't asking for any variances, but it's called a zoning review, and there's a provision of the ordinance that says if your property was a subject of a zoning approval before the various boards, you're required to come back to that board. So they've had to come back, and I'm starting to get questions, do they have to come back for solar panels, fences, stuff like that are kind of relatively minor in nature that may be kind of onerous for someone that's like pulling a permit. So we may want to take a look at that ordinance just to review whether it's actually capturing what it's intended to do or torturing people to doing little things to their property that are normal maintenance kind of stuff.
Yeah, you want to do something fairly innocuous, but because you had gotten a variance.
Yeah, that makes sense.
Yeah, so I know we kind of paused our implementation and we were looking for some definitions for workforce housing and stuff like that. So I think in the future, as the agendas will allow, we'll start attacking some of this stuff.
Is parking on your list of things we
Well,
want?
we're coming up to all the big parking issues, so yeah, that's on the list.
Okay, that'll be good.
I know that you're waiting for that.
I am. Back to it.
Okay, we have a motion to pay the bills.
I'll make a motion.
I'll second.
Mr. Gorgon motions, Mr. Crippen seconds. Mr. Gorgon?
Yes.
Deputy Mayor McDade?
Yes.
Mr. Crowley?
Yes.
Mr. Lundholm?
Yes.
Mr. Paducis?
Yes.
Mr. Crippen?
Yes.
Mr. Brazier?
Yes.
Thank you.
Anything else for the board?
Motion to adjourn?
Hey, thank you, Dennis.
All in favor?
Aye.
Thank you, everyone.
Thank you.
I agree.